Hello, and welcome to the third webinar in our six-part series on sexual harassment and assault in the workplace, brought to you by our working group, comprised of members from the Section of Civil Rights and Social Justice, the Commission on Women in the Profession, the Commission on Domestic and Sexual Violence, the Commission on Sexual Orientation and Gender Identity, and the Young Lawyers Division. My name is Paula Shapiro, and I am the Associate Director of the Section of Civil Rights and Social Justice. I encourage you to check out our section's website, www.americanbar.org/CRSJ, for news and information and replays of our great programming focused on the impact of our current administration on civil rights and civil liberties. During today's program, if you're so inclined, you can ask questions of our panelists by finding the questions box on the right-hand side panel and typing in your questions. You may also access our 5 handouts by locating the handouts dropdown and clicking there. Finally, we will be sharing a recording of this program to everyone who is registered so that you can share it widely with your networks, and copies of the PowerPoint presentations and handouts will be included. I'll now turn it over to our section and committee member, Kathy Trawick. She is the Executive Director of the Tennessee Fair Housing Council.
Thanks, Paula. So we've been having the webinar on how sexual harassment affects women in the workplace. But thanks to the Me Too movement, sexual harassment has finally come into the daylight, especially in the employment arena. However, the indignities and harassment that women suffer at home at the hands of their landlord aren't always thought about or talked about. And that's the one place that a woman should be able to go and feel safe. So the Fair Housing Act makes it illegal for a landlord to condition a woman's housing on her acquiescence to his demands for sexual favors. Though it's well-established in current case law, we'll discuss quid pro quo, hostile environment, and other situations that arise in the context of housing, both subsidized and non-subsidized. And we'll also talk about their rights and remedies. We also have with us today Kelly Clark, who is a supervising attorney with the Fair Housing Project of Legal Aid of North Carolina since 2011. And she'll be talking about a case that she had along with Chris Brancart of Brancart and Brancart and Craig Hensel of Hensel Law, where she represented 16 women in a sexual harassment federal case. And she's going to talk about that case with you and talk about some of the good results that they got from the women in that case. And then we also have Catherine Raimondo, who's a trial attorney in the Civil Rights Division with the Department of Justice. As a member of the Housing and Civil Enforcement section, Ms. Raimondo investigates and litigates violations of the Fair Housing Act, Equal Credit Opportunity Act, and Title II of the Civil Rights Act of 1964. She recently litigated a case against the Kansas City, Kansas Housing Authority and 3 former employees involving allegations of sexual harassment, which also resulted in a settlement compensating 14 victims of harassment. She will also talk about an initiative that the Department of Justice has launched to educate more people about fair housing. So we'll get started with our PowerPoint, and we've got some polls for you. Let's see. Okay. So I'd like everybody to look at this, and I want to talk about how fair housing does relate and intersect to other parts of the law. Wait just another minute or so. Okay, so we're about at the end of the poll, and it looks like 38% of you said true and 63% said false. And so actually that is false, because the Fair Housing Act, when you get into different protected classes, even if you practice elder law or other areas of the law, you may be talking with your client and learn that something about their housing is a problem, whether it's their lease is being terminated or whether or not they're going to have to move because they can't get in and out of their house. So I'm hoping that even if you don't practice housing law, that you will take something away from this that will kind of help you with some issue spotting and get in, you know, kind of always have that in the back of your mind. So what is meant by the term discrimination? It's actually, a lot of people think it's unfair, but it's really a difference in treatment because of membership in a protected class. And sometimes I have to tell my clients that not everything that's unfair is illegal. If the landlord is just mean or unfair to everyone, then there's a good possibility it's not going to violate the Fair Housing Act. So the federal protected classes are race, color, religion, national origin. In 1974, sex was added. And in 1988, the act was amended to add familial status and handicap, which we refer to generally as disability. So also today is actually the 50th anniversary of the day that the act was signed. So I have another poll for you, and sorry. So when you think about fair housing, which of the protected classes do you think about the most? What is the first one that comes to mind? Okay, we'll wait just another couple of seconds. Okay, so 93% said race or color, and 32% said religion, 43% national origin, 46% said sex, and 61% said familial status or disability. And in the last few years, disability has overwhelmingly become the most frequently litigated protected class. I really believe that after the Me Too movement, that we will start seeing a whole lot more cases in sex. So who has to comply? Housing providers, whether it's subsidized housing or non-subsidized. That means if it's based on your income or not. So even private landlords have to comply with the Fair Housing Act. Management companies, homeowners associations, those are some of the most frequently litigated also, because a lot of homeowners associations don't believe that the Fair Housing Act applies to them. And then, of course, owners of the property. So you may have several layers. You may have the actual person. Let's see. Oh, I'm sorry, my PowerPoint's not showing. Sorry. We'll try and get that back up. I apologize for the let's see. Okay. Hopefully it's back up. Well, there we go. Now, so you have to have a dwelling, and what qualifies as a dwelling? Well, basically it's where the person lives, and it even includes shelters, migrant housing, dorms, that sort of thing. So really it's where the person lives. So Marvin is homeless and living in his car. His car is inoperable, so he can't move it every 72 hours in compliance with the city ordinance. One day he comes back from work and discovers that his car's been towed because he couldn't move it like the ordinance required. So unfortunately, it's a car and not a dwelling. But he wants to file a complaint. So I want to see what you think is, can he do anything about that? I'll give it just another minute or so. It looks like it's kind of split 50-50. It looks like it's split about 50-50. And interestingly enough, recently there was a case that that very case, and the court determined that yes, his car qualified as a dwelling, and so he was protected under the Fair Housing Act. So I want to talk a little bit more about sex discrimination. There's several categories. You have your traditional, which is based on sex, where like women who are victims of domestic violence fall into this category. Tenants who don't fall under general norms. Then you also have quid pro quo and hostile environment. And we're going to take a look at each one of those a little bit more. Domestic violence. Discrimination against victims who are survivors of domestic violence has been determined to be a violation of the Fair Housing Act because of its disparate impact on women. And so what that means is it's a neutral rule that has a proportionately larger impact on one group over another. So since women tend to be more likely victims of domestic violence, then that's how it, because of the disparate impact, it falls under sex discrimination. Now, Congress has enacted VAWA, the Violence Against Women Act, and but that only applies in HUD properties, in subsidized housing. So it gives people several protections, and it requires housing authorities and other subsidized properties to do certain things, but it only applies, it does not apply in what we call market rate housing. Also, you don't have a private right of action under VAWA. It's not really clear what happens if the housing authority doesn't comply based on VAWA. So because of the Fair Housing Act, women are able to piggyback the VAWA and file a fair housing complaint if the housing authority doesn't do what they're supposed to do. So this is just kind of a comparison for you to keep that talks about whether or not VAWA or fair housing applies. But just remember that really anything that VAWA applies to, fair housing also does. So here's our last poll, that because sexual harassment is not a protected class under the Fair Housing Act. So unless your state has added it in one of their protected classes, then same-sex couples and transgender persons are not protected. So we're talking straight under the Fair Housing Act, not your state's law. Okay, we'll give it just another second or two. Okay, so good. That 64% of the people who voted said that that was false, and that is correct. It is false. If the couple is a same-sex couple whose partners are female, the same analogy used for women in heterosexual relationships would apply. The analysis of the disparate impact theory would be the same. The law and statistics state that women are much more likely to be victims of domestic violence. The statistics focus on the victim, not the abuser. So if you were filing a complaint based on domestic violence and not the sexual orientation of the victim, that's where you would want your focus to be. And when you were discussing it with the HUD investigator or your state investigator, you wouldn't want to get drug off into the weeds. You want to keep it focused. Now, if the couple is a same-sex couple whose partners are male, the statistics would not help, but it could be workable if you can show the intent to discriminate is because the victim is male. The landlord thinks that the victim should man up and handle it. Now that's in the context of domestic violence. And when you're talking about sexual orientation, even if it's just a same-sex couple or a person who's transgender, then HUD has expanded the protection, and you've got quid pro quo and hostile environment liability for discriminatory practices against all forms of harassment, and it includes neighbor on neighbor. And then as it applies to HUD housing, you have the equal access to housing regulation that applies to HUD, only HUD housing. And then the really good part that's new is that HUD will also accept and investigate complaints against private landlords or subsidized where sexual orientation, gender identity, or gender expression are at issue to see if they are covered under sex. And what that means is we look at it as the person, the resident, does not fit into the landlord's stereotypical attitude of how that gender should dress or act. Men should dress like men, women should dress like women, men should date women and vice versa. So if the landlord is treating them like that, that's the way we look at it, and HUD looks at it, and it does fall within harassment based on sex. Also, if the landlord assumes that a person is gay, they must be HIV positive or have AIDS. And again, that makes them also fall under the category of persons with disabilities, because a person who's HIV positive or has AIDS is considered a person with disabilities. So we just talked about that HUD has expanded these regulations to include harassment of all the protected classes. So that's really good. Today we're just going to focus on sexual harassment in housing. So here's the regulation where they've expanded it. Now, quid pro quo is defined as an unwelcome request or demand to engage in contact where the submission is made a term of condition relating to the rental of the housing, the availability, terms and conditions, or the availability, terms, or conditions of a real estate related transaction. An unwelcome request or demand may constitute quid pro quo even if the person acquiesces in the unwelcome request or demand. And that's pretty huge. Hostile environment is unwelcome conduct that is sufficiently severe or pervasive as to interfere with the same situations under quid pro quo. But this does not require a change in the economic benefits, terms, or conditions of the dwelling or housing. So what that means is you can have a hostile environment complaint even if the landlord has not taken negative action against the resident. Under hostile environment, they look at the totality of the circumstances. So they look at the nature, the context, the severity, scope, and frequency, and the relationship of the persons involved. The liability, the direct liability is, of course, they're liable for their own actions or failure to take action to correct a discriminatory practice. And then vicarious liability applies to the agent or employee, regardless of whether the person knew or should have known. So that's important to think about, especially even if you represent landlords, because they're responsible for the actions of their employees. A lot of times it's a maintenance man. They're also responsible if someone comes to them and tells them about a neighbor on neighbor harassment and they fail to take action. This is where homeowners associations come into play, management companies. It can even reach as far as a housing authority, even if it's Section 8 housing. So these are some cases that kind of pull everything together. The Woods v. Foster case, this was a shelter where women, it was a shelter for women where the maintenance man was demanding that the women have sex with him, or he would not only get them put out of that shelter, but he would also have them denied any other shelters because he'd tell everyone that they had stolen. So he was going to get them put out of that and essentially make them homeless. And so the women most of the time gave in because they felt like they didn't have a choice. And the court said that under these circumstances, because the maintenance man was using his power and threatening them, that he was going to, they would give in, but the court said that didn't matter. And so that's really good. The Haunts v. Vigil is good, is a good case because it really it shows what doesn't rise to the level of a violation. The Shellhammer versus Llewellyn, this is another good case where the analysis in there is what's important, because the court goes into discussing what rises to the level of hostile environment. And then this Marcius v. Lang is another one that talks about how much is enough to be pervasive. This case right here, the United States versus Weigel, and it's in your attachments. And my client, this was a case that I had, and my client, Kayla, was going to be on the call today, but she had a run-in with a deer this morning and was not able to join us. Fortunately, she's okay. She just wasn't able to be on the call. So this case began as a complaint with HUD. Her landlord was texting her, wanting her to allow him to take nude photos of her. Now, she had just moved in. She'd paid a month and a half of rent in advance, but her son needed to have tubes put in his ears. So while she was off with him, she didn't get paid. And of course, you know, she got half a month behind on the rent. And so the landlord began texting her and wanting her to let him take nude photos of her. It was just constant. She fortunately had kept her phone, and so we used a court reporter to transcribe all of the text messages. And even just over a few week period of time, I can't remember, there was well over 100 texts between them. And his house sat up on a hill behind hers, and so he could look down at her, at her house. And when she got scared and wouldn't stay at home, he sent her a couple of text messages that said, are you ever going to come home? So, you know, he was watching her. He was bombarding her with text messages. He wanted her to take photos of him in some lewd acts. It was pretty awful. She first went to the sheriff in her county because she knew him, and he basically told her that there wasn't anything he could do. Somehow she found her way to legal aid in Jackson, Tennessee, where I was working at the time. And, you know, when I saw it and saw the text messages, I knew that there was a case. So we filed a HUD complaint. We assisted her in filing a HUD complaint. And we went through the HUD investigation process. And in the process, we discovered that the landlord had gone into her house when she wasn't home under the pretext of installing her internet on her computer. And in doing so, he took some pictures off of her computer that were just intended for her fiance at the time. And she didn't even share them over the internet with anybody. And yes, they were very, very personal is the best way I'm going to describe them. Well, during the investigation, he shared those with the HUD investigator and said that Kayla had willingly sent those to him. So that kind of took everything off in the weeds, and it took a little bit to get it back in, but we had the Woods v. Foster case on our side, because even if she didn't share them with him, but even if she had, at the moment that she said, no more, I'm not going to do this, then it fell within when he persisted. And finally, he gave her an ultimatum and said, if you don't do this, you're going to get your eviction notice tomorrow. And she said, I'm not doing this. And finally, he gave her it. She came home and found it laying on the counter the next day. And of course, she didn't want us to help her stay in the house. She just wanted to do something about it. One of the things, so HUD found cause, which meant that they found there was enough evidence to believe that discrimination had occurred based on sex, and it was also quid pro quo and sexual and hostile environment. And the reason it was hostile environment, even though it was over just a few weeks period of time, is because of the pervasiveness and how bad those text messages were. So she had a choice of going to an administrative law judge or electing to federal court, which is what she chose to do. And at that point, the Department of Justice intervened, and that's why the case is styled U.S. v. Weigel. But we also assisted Kayla in filing a motion to intervene, and that way we were representing her, because the Department of Justice represents the United States and their interests. They do have interests in common, but when possible, we like to assist our clients and intervene, and that way we can advocate straight for them too. So I've also attached, we've got the, right now we've got the DOJ complaint attached, and the defendant filed a motion for summary judgment. We had a little hiccup because without knowing that she should have let me know, Kayla had filed bankruptcy right after she filed the HUD complaint. And the opposing party found out about that. They filed a motion to amend their answer, and it was granted. We, in turn, filed a motion to substitute the bankruptcy trustee as the real party in interest. And Kayla is, that's why I really hate that she couldn't be on this morning, because she is such a remarkable young woman. A lot of women, when they found out that most everything would go to clear their bankruptcy because it was a Chapter 7, then they would have dropped out. But she persisted. And as it turned out, she had not used all of her exemptions, so she was able to recover some damages. but she didn't care. For her, it was more about what he did and making sure that he didn't do that to anyone else. So she's just a remarkable young woman. And I should mention that she did tell the her bankruptcy attorney's paralegal, but I suspect that if you say I filed a fair housing case to a lot of attorneys, they wouldn't really understand what to do with it. And so when you read the judge's decision, you'll see that he took that into consideration, and also the fact that we filed the motion to substitute before the motion for summary judgment was filed. So it's a really good analysis. It goes through not only bankruptcy, it's kind of like a bonus for you, but it goes through the bankruptcy analysis, and then it goes through each of the causes of action, what the defendant's response was, and how we were able to overcome it. So what happens if you do have a fair housing complaint? So unlike employment law, you do not have to exhaust the administrative process before filing a lawsuit. You can file a complaint with HUD within 1 year from the date of the last act, or you can file a lawsuit in federal court within 2 years from the date of the last act. Now, you also want to check your own state laws if you have an equivalent state law, because it may differ from the federal statute of limitations. Here in Tennessee, we have a substantially equivalent law, but the statute of limitations is 180 days in which to file a complaint with the state agency and 1 year to file in state court. So you want to be sure and check your own state laws. So this is my contact information, and also for the Department of Housing and Urban Development, their website. You can file complaints online, and or you can look and find your own local office. So I wanted to check. We'll see if I've had any questions right now, and I don't. Let's see. Okay. Okay. Someone had said that their area of practice was civil prosecution against landlords for a municipal agency. And it's possible that depending on what the cause of action was, if it had to do with a zoning ordinance or something like that, and the person, especially if the person was disabled, then it might possibly have crossed over into the Fair Housing Act. So again, that's what you might do. It looks like I had a message a couple of times that maybe my PowerPoint went in and out and you couldn't see it. It is attached to this for you to print off and take copies of. So I hope you'll do that. And I apologize for my technical lack of, or so, I don't know. But anyway, so now I want to turn it over to Kelly Clark with Legal Aid of North Carolina. She and I go way back because our organization in Jackson helped Legal Aid of North Carolina get their fair housing project going. So I've known Kelly for a long time, and she has a really cool case to talk about.
Thank you, Kathy. Hello, everyone. Very excited to be here. Very excited because Kathy is the one that's trained me at our Fair Housing Project at Legal Aid of North Carolina. So I'm very happy to be joining her today. The case I want to just talk about with you all is it's the Christian Sellers et al. Versus Southeastern Community and Family Services, John Wesley and Eric Pender. This was one of the first sexual harassment cases that I worked on once I came to our Fair Housing Project. I've been a legal aid attorney for about almost 16 years, had worked in various local offices, and then in 2011, with Kathy as our monitor, Legal Aid of North Carolina, we received a HUD grant to do exclusively fair housing work across the state of North Carolina. So we're a statewide project. And so this is one of the first cases that I worked on. I'm very happy that I was able to. But to start to talk about the case, I want to give you a little bit of the background of it. And then I want to talk more or move into or segue into how the case kind of came to be, or my office's involvement, and also who we collaborated with, because that was huge in this case. And it's also Katie's office is one of the main players of the agencies that we collaborated with. So I want to give you that background story that you might not be able to, if you ever read about the case, you wouldn't know about. And then I want to, from there, go into mediation and how we were able to get the result that we did for our clients, as well as for other aggrieved persons. So the background of the case is that it's pretty much of the acts that occurred were in Scotland County, North Carolina. It's very near from where I grew up in North Carolina. It's a rural area, southeastern North Carolina. And Southeastern Community Family Services, their former name and what they're pretty much still known as, but they did change their name throughout the lawsuit, is 4 County Community Services, 4 County. When you've talked to anyone down there, it's 4 County was the shorthand. And they came to be probably, I think it was in the late 1970s, early 1980s, and they provided services throughout the county to folks, and it was like Head Start, utilities, and also they came to administer monies from the U.S. Department of Housing and Urban Development, HUD, for what you may have already heard about as a Section 8 program, Section 8 voucher program. And that program is a housing assistance program where the assistance follows the tenant into the community. So the assistance with the housing doesn't stay with the building like with public housing or so forth. So if a tenant leaves in public housing, they don't get the assistance to go with them. So these vouchers are very much sought after. There can be waiting lists to get these vouchers. Once someone gets the voucher or their name comes up on the waiting list can be across, nationally, but can be like 5-10 years. The assistance that the tenant gets is that the federal government will pay a portion, if not all of the rent. It's based on the tenant's income. And so 4 County, or now Southeastern Community Family Services, they administered that program in Scotland County. And in a rural area with it's nationally lack of affordable housing, but particularly in a rural area, this is where it's at if you need to get you need to get assistance with housing and you don't have the means. And so they were pretty much the only game in town. There was also a Laurinburg Housing Authority that they were not part of this lawsuit. They were where some traditional public housing was administered, but for the voucher, it was only 4 County that was administering that. They had, as like with other housing agencies, a waiting list for the vouchers. They go back several years. 4 County had with their waiting list, they had what was called points. If you were a survivor of domestic violence, you got more points. That would then rise you up more on the waiting list. If you were homeless, more points. If you had a disability, more points. And this process with the waiting list and the points became something that we had to look at in this case, and I'll explain more in a bit. So that's how Section 8 works. It also, when you get a voucher, when a tenant gets a voucher, he or she just can't use the voucher right away. And what I mean by that is that they have to find a house, apartment, or so forth that it falls within the payment standard of what they can use their voucher for. But it also has to pass what's known as the Housing Quality Standards, HQS, inspection. And because HUD's not going to pay for or help pay the rent for a unit if it doesn't pass the inspection of or meet the housing quality standards. And so with pretty much with any housing agency, you have administrators who are looking to see when, who are monitoring the waiting list and who decide who gets the voucher, when their time is up and so forth, how many points have they gotten their certain points in order to get the voucher. And then you have an inspection department, and they are the ones who will inspect the unit, inspect the home to see if it passes the inspection. Because once that happens, that's when the voucher can be used. If the home doesn't pass the inspection, then the voucher can't be used. So I say this is that there's an awful lot of power in these positions. The one who is determining who gets the voucher and the one that's determining if the house passes the inspection for the voucher to be used. The other thing is that once a tenant gets a voucher, the house has to pass each year the inspection in order to keep the voucher. So who the main players were in the lawsuit, it was obviously Southeastern Community Family Services, Fort County later name, and also the allegations, which were all denied and continue to be denied. But with John Wesley, he had been at Fort County for many, many years. He used to be an inspector, and then he was one of the administrators who were the ones that picked who got off the waiting list and who would get the voucher. And then you also had Eric Pender. He was also an inspector, so he was the one determining who was going, which voucher, which home was going to pass inspection. So very prominent positions of power. And so the survivors of this, the allegations were people who are women who were required to perform sexual favors in the offices of Fort County, Southeastern Community Family Services in order to receive a voucher. When inspections happened, the allegations were women were required to perform sexual favors in order for the homes to pass inspection in order to use their voucher. There were also allegations of, in order to get the points up, if someone who had, let's say, a background in or had a history of depression or of a mental illness, there were allegations that they were referred by Mr. Wesley and others to some other gentleman, I shouldn't say gentleman, but some other person to perform sexual favors in order for that person to write them a letter to say, oh yeah, they do suffer from depression, to get their points up on the waiting list. So there were a variety of allegations that were being alleged. What we found through our investigation, there were, mothers, daughters, sisters, cousins, all being hit with these demands. Some didn't know that they had been approached. They didn't talk to other family members about it. Investigation showed that some of this went back to 1989. But those were the type of allegations that were being alleged in this case. How this moving back from the background to kind of how this case came to be. This case first started with Craig Hensel. Really, she first started with Christian Sellers. She was the one who approached Craig Hensel. He is a private attorney, primarily doing employment discrimination. He had just started practicing. He was probably about a year into practicing. And Ms. Sellers had gone to other attorneys, and essentially what she understood was she had to get more people to sign up in order for her case to be looked at. Ms. Sellers had just gotten out of prison. She was trying to turn her life around. Her name came up on the waiting list. She had found a place to rent, but was told that wasn't acceptable. And actually it was Mr. Wesley and Mr. Pender, according to her, that told her she had to rent this particular mobile home, which was in complete disrepair. She worked day and night to get it cleaned and so forth. And her allegations was that Mr. Pender would keep coming by demanding sexual favors, which she did not do or perform, but to pressure her into having the home pass the HQS inspection so she could start using her voucher and getting the housing assistance. And so she approached, after trying to find an attorney, approached Craig Hensel. He's based out of Greensboro, North Carolina. And other people came forward that she knew, and he filed, after talking with some folks, he filed a lawsuit in Scotland County Superior Court, so in state court. And he was not aware of the fair housing angle of this. He was looking at mostly torts of assault and battery, negligent supervision, negligent hiring, and so forth, and brought that into state court. Publicity came out about the case, and more people came forward. So he had, I think it was a total of 8 plaintiffs when my office first learned about the case. And one of the plaintiffs had contacted legal aid. There were concerns about the voucher, right? And we have a centralized intake unit at my office at Legal Aid of North Carolina, my organization. And I was called directly by my former supervisor, and she was like, "Kelly, you gotta hear about this case," because there had been some news articles written about it. And I had just moved over to this project, so this was people at Legal Aid of North Carolina. They have filed sexual harassment cases. My background was primarily in disability discrimination. I had just before learning about Craig's case, had filed with one of my colleagues a sexual harassment case up in Hertford County, North Carolina. So I was new to this area. And so I reached out to Craig, gave him the information that I had pulled from the Brain Carts and Brain Carts, looking up their cases in Pacer, Diane Citrino, the jury instructions, all that information, and was talking to him about the voucher angle and my background, because I, as a legal aid attorney, I certainly know that background. And so he and I would go back and forth and talking. And when I talk about the case, I say it's kind of like being asked out on the date. Like, no attorney wants to say, "Hey, do you want us to work on your case?" Because that's his case. But within the next month, I went to the NAFA, the National Fair Housing Alliance conference in DC, and I had approached Chris Braincart. I had been trained by him and his wife at various other like CLEs and so forth. And I just approached him. He was one of the presenters. And I said, "In any way that you could talk to this young attorney about a case that he has, I think is pretty big." And so Chris spoke with Craig and convinced him to ask my organization to get involved in the case, which was wonderful. And so Craig and I worked on the case together. And at that time, I had been working with the DOJ in a limited capacity on one of their cases that they had in North Carolina, answering discovery. And one of their attorneys was like, "Kelly, if you ever have another case that you want us to look at, reach out to us." And so Craig and I did. And the DOJ began investigating the case. And Katie will go into that more, because they have some special tools in their toolbox that we don't have, or many special tools, I should say. And so they were able to do some things that we couldn't do. But in regards to other survivors that were out there that were outside of our statute of limitations, the 2-year. And so we got, Craig and I were working on the case. I got to know more of the plaintiffs, and then we moved to amend the complaint to include the Fair Housing Act as a claim. And we didn't change any of the facts. We just were including that claim. The defendant's attorneys, they did not oppose the motion to amend, and the motion was granted. And right after that, the defendants moved to remove the case to federal court here in the Middle District of North Carolina, which was great. We wanted that because the DOJ and us to be involved with them, they're not getting involved. I don't want to speak for you, Katie, but this is what I understood, was not going to get involved in the state case. They're going to file, if they were going to file, would be in federal court. So once they removed it to federal court, we didn't oppose that because we knew the DOJ was investigating, and our hope was that they would file and that we could move to consolidate our case with theirs, and so forth. So the case was removed. At that time, I was working, or my organization was working with Braincart and Braincart on that sexual harassment case. So when I approached Chris at the NAFA conference, say, "Hey, can you talk with this young attorney?" He talked to them, was like, "Hey, but how about we help you with your case?" Because how they roll is that they want to help other advocates out there learn how to do these cases. So they had gotten involved in the case that I had just filed with my colleagues. And so we were in the middle of a deposition of that case when we find out that the Southeastern Community Family Services case had been removed to federal court. And then Craig and I asked Braincart and Braincart to get involved. So that's how that all kind of came to be, of us all working on the cases, which is so important about collaborating and knowing people and reaching out when you need to, or even if you don't know if you need to, but just doing that. And then as that was progressing, the DOJ, we also had gotten the ear of Sarah Pratt, who is now with Relman, Dane, and Colfax, but before that, many other places, but at that time she was at HUD. And so this case had her ear. And she was, her office was working on the case as well and working with the DOJ. The DOJ, so the case was removed to federal courts, I think it was like in April of 2014. The DOJ then filed their case in December 2014, and then the cases were consolidated, I think in January or February of 2015. And so we were representing at that point, the case had grown to about 16 private plaintiffs. In the caption, I know there is the consent order that you have to review. We only have 15 women, I think, in the caption, but we had found someone else, and she was about to be included in the case right before we went to mediation, but we mediated on her behalf. So it was a total of 16. So they were the private plaintiffs, and then you had the DOJ. So we all went to mediation together. But what was also key right before mediation in May 2015 was that HUD had issued a letter to Southeastern Community Family Services basically that said if they did not resolve this case, they were going to lose their funding for the Section 8 program. So that was a huge, some leverage going into mediation. But as more and more about the case was coming out, obviously you can understand how women were scared to come forward because, you know, we come down for the case, but they have to live there. We leave, they're there. But more and more people were coming forward, and with the DOJ, they can, with their case, they can get recovery for these people, even though their client is the United States Department of Justice. What was also so key, what I learned about in filing in federal court, is the unique with the rules of federal
I think we lost Kelly for a minute. Maybe she'll make it back. While we're waiting on her computer to clear up, someone had posted that they have dealt with prosecutions of landlords for a municipal agency, primarily based on lack of repairs. And we've discovered that a lot of our cases come in that way as an eviction case or something that starts out as what we think is a landlord-tenant case. But as we dig into it, we discover that it's only minorities that are being treated that way, or limited English proficiency, or persons with disabilities, whoever the landlord feels is not their desirable client or tenant. And so they will evict them, and they'll come up with some sort of reason. So hopefully if you're in that situation, then you'll be able to assist that person accordingly. And also they talked about that New York City has no Section 8 vouchers left, and unfortunately that's true pretty much around the country. The only time you can get on the waiting on a Section 8 voucher is when someone goes off the program. And that's why we who deal with a lot of clients that are on subsidized housing programs, we fight so hard to keep those vouchers. So it looks like something happened with Kelly's computer. We love technology. So we'll go on and let Katie Raimondo with DOJ get started. And then if Kelly comes back, if she had anything to add, we'll let her talk. Okay, go ahead, Katie.
All right, that sounds good. I'll take a step back if Kelly comes back, but I think I can build on some of the things that she was talking about. So, hi everyone. I'm very happy to be with you this afternoon. So, my name's Katie Raimondo. I am a trial attorney with the Civil Rights Division of the Department of Justice. Within the Civil Rights Division, we have various sections. I work in the Housing and Civil Enforcement section, which is the section of DOJ that enforces the Federal Fair Housing Act. So a couple of questions I want to cover in my portion of the presentation. One is, what is DOJ's enforcement authority in Fair Housing Act cases? Two is, how does DOJ litigate cases? And then three, what are we doing to combat sexual harassment in housing? So the first question is the enforcement authority under the Fair Housing Act. And to understand DOJ's enforcement authority, I just want to remind you of what the options are for private plaintiffs, which Kathy discussed. There are two options for private plaintiffs to file their own claims under the Fair Housing Act. There's the option to file a HUD administrative complaint, which needs to be filed within 1 year after the discriminatory act. And then private plaintiffs can also file federal court lawsuits, and those have to be filed within 2 years of when the discriminatory act occurred. DOJ's enforcement authority and jurisdiction is a little bit different. In general, under the Fair Housing Act, the Department of Justice can only bring cases where it has identified a pattern or practice of discrimination. So that means generally that we have to have identified multiple victims in order to take action. There's one exception, which is what Kathy had been speaking about, her client Kayla's case in a HUD, what we call a HUD election case. That's where a complainant files an administrative complaint with HUD. HUD finds merit and issues a charge of discrimination, and then that specific complainant can elect to have the case heard in federal court, and DOJ is obligated to then bring a case on behalf of that individual. As Kathy said, the individual complainant can also intervene in the case, but they don't have to. And DOJ will litigate that case and seek relief on behalf of that individual. But other than those HUD election circumstances, in general, we can only bring cases where there has been a pattern or practice of discrimination identified. And the language on this slide, which hopefully you can see my slides, the language here is from a court decision that recognizes that a pattern or practice claim brought by the DOJ is a single claim. It's not individual claims on behalf of each individual victim in the case. And that's particularly important for the next point that I want to talk about, which is DOJ's statutes of limitations. So there's three different statutes of limitation that apply to discrimination claims brought by DOJ, and they correspond to the three different types of relief that we can seek in our cases. The first and probably most important is the statute of limitation for damages. So the Department of Justice can recover damages on behalf of aggrieved persons. Those are individuals who were harmed by the discriminatory conduct. And our statute of limitations, the language is on this slide. It's basically 3 years from when we discover the conduct. So most importantly, that means that we can obtain relief for people who were discriminated against and were harassed many, many years before. So this is what happened in the case that Kelly was talking about, whereas they were able to bring a private lawsuit on behalf of women whose claims were timely. They fell within the 2-year statute of limitations for bringing private federal lawsuits. Once the Department of Justice got involved and investigated, we were able to bring a case that sought damages on behalf of individuals that were harassed going back to the 1990s or the early 2000s, people whose claims would not have been timely. Just recently, within the past month, we settled a lawsuit against a private landlord in the St. Louis area. The allegations in that case went back to, I believe, the mid-1990s. We were able to recover, I believe, around $600,000 in damages for 15 aggrieved persons in that case. So the type of damages that we generally recover are emotional distress type damages, potentially out-of-pocket costs as well. And if we're able to settle a case at the early stages of a litigation, we'll often set up a settlement fund so that we can continue to investigate and identify additional aggrieved persons that may get payments out of that settlement fund. So the two other types of relief that we can get have different statutes of limitation. We often seek civil penalties that would be paid to the United States. The statute of limitations for those damages, that's 5 years from when the act occurred. There's no separate discovery rule there. And then we also seek injunctive relief in our cases, and there is no statute of limitations that applies to DOJ's ability to get injunctive relief. Often what that involves is an order that the harasser can no longer be involved in property management, and we require that the harasser generally get out of the business of interacting with tenants. If the harasser is an owner of properties, we will require them to hire an independent manager so that they have no responsibilities that would involve interacting with tenants. Obviously, they would also be prohibited from interacting with any of the individuals who asserted claims against them. If the defendants in the case are a housing authority or a property management company, it will often also require them to implement non-discrimination policies or complaint procedures, training requirements to make sure that this conduct is addressed if it is reported, and to stop it before it goes on for a pattern of many, many years. So, kind of the takeaway is that even though, you might be representing a client and you can take action on behalf of that client and file your own HUD complaint or private lawsuit, there are certain things that, DOJ can bring to the table. We have the ability to investigate and potentially uncover this larger practice of discrimination. We can potentially get the harasser out of the business of property management and take actions on behalf of people that may not have their own ability to file private claims. So I also just want to talk briefly a few unique kind of specifics about how DOJ investigates and litigates cases. One question might be, where is this happening? Where are you taking action? The answer is kind of all over the country. So this is a map of all of the litigations that we have filed alleging sexual harassment under the FHA since the year 2000. I think it's missing one that was recently filed in Wichita, but is otherwise up to date. And the cases that we litigate involve all types of housing. It's not just public housing, although sometimes it is. Often the cases are brought against private landlords that are renting all types of housing. Single-family homes, high-rises, mobile homes, both in rural areas. We've had a case in New York City. Really, it just runs the gamut. And even though there are some blank spots on this map, we are sure that sexual harassment is happening in areas where we have not taken enforcement action. And so that's one reason why I'm thrilled that we could be part of this presentation today, because we kind of want to get the message out that about what DOJ can do in this area, and really emphasize that we want to be taking action really all across the country, because we're sure it's happening everywhere, and we want to encourage more people to get in contact with us about this conduct. The cases that we bring come to us from a wide variety of sources. Sometimes, legal aid organizations like Kelly's organizations bring them to our attention. Sometimes private attorneys. We monitor news reports and, litigation dockets of private litigation. So anywhere that we can, see that this might be happening is an area where we might investigate. And then I just want to say a couple things about how DOJ litigates cases. One, as actually I think Kathy mentioned, when DOJ brings a case, it is brought by the United States. The United States is the plaintiff in the case. We do not name the victims or survivors in our complaint, with the one exception of the HUD election case that I spoke about, where an actual complainant filed something with HUD. In that case, we would mention that particular complainant and the allegations that she's made, but for a normal pattern or practice case, we would not be naming victims in our complaint. We can't say that a victim's name might never be revealed. That may happen when it comes to the time of settlement, but they will not be publicly named when the lawsuit is initiated. This next slide is just an example of how we generally describe allegations in the complaint. Again, they would generally be not tied to any particular individual. They would be general in nature. The other point I want to mention is the protective order, which is something that we would seek very early on in our cases to make sure that sensitive information about victims is protected throughout the litigation. Most importantly, this would also involve a no contact provision between the defendants and the aggrieved persons or the victims that are making the allegations in the case. And one thing I don't think was mentioned, but we should mention that the Fair Housing Act prohibits retaliation against anyone who is asserting their fair housing rights. So that's illegal under the FHA for a landlord to take action to evict someone or take any other kind of adverse action because a person has made a fair housing claim against them. And so I just want to end briefly by talking about an initiative that DOJ has launched recently that's specifically focused on this issue, on sexual harassment in housing. A little bit about why we chose to do an initiative specifically in this area, and it's kind of based on the problem of underreporting that we believe exists. We've been doing these cases for many years, and often in the course of receiving a referral about something that's happened to one or two individuals, when we do an investigation, we often find many, many other victims who didn't come forward on their own. We know that people who are experiencing harassment in housing are not reporting it. And we know that when it's happening, it's often, in the vast majority of cases, happening to more than one person. So what we commonly hear is victims either didn't know what was happening to them was illegal housing discrimination, they didn't know where they could report it, or they did report it to someone, as Kathy's client did. Maybe they reported it to law enforcement, or maybe they reported it to someone at the public housing authority if they were in public housing, but that person didn't know where to refer them or didn't do anything to help them. So kind of given this background, what we've learned from our investigations and litigations, we decided to launch an initiative to increase awareness of the problem of sexual harassment in housing. Awareness both that this conduct violates the Fair Housing Act and that DOJ investigates and enforces this law and wants to hear about these cases and take action on behalf of women and victims who are experiencing sexual harassment in housing. And the initiative really has two separate target audiences. First, people who they themselves may be victims of sexual harassment in housing, and the friends and family members that they might report this conduct to in the first instance, but also to the service providers who these victims may be coming to in the first instance. So law enforcement, legal services organizations, maybe shelters, domestic violence or sexual assault crisis centers, people that may be hearing about this but don't know that they can, refer individuals to the Department of Justice. And there may well be other avenues for reporting this. HUD, a local state fair housing group or fair housing agency, maybe law enforcement if it rises to the level of sexual assault. But we also want to encourage people to refer these cases to the Department of Justice. As I said, while we don't normally take action on behalf of a single individual, sexual harassment cases are unique in some ways because they often always involve more than one victim. So, we want to hear about it even in that instance of just one particular individual in the hope with the assumption that we may be able to uncover many more victims in the course of investigating. And so what we've been doing as part of the initiative is working on various outreach tools that are directed to both of these targets. We've been holding roundtable discussions with key service providers and a number of local communities just to identify ways that we can collaborate and increase awareness in that local community about this problem and to encourage reporting to DOJ. And so far we've received a lot of positive feedback, and we've really learned a great deal about the best ways to reach our target audiences. This page, last slide, which is also in the handout materials, has a website that we've developed specifically for this initiative. On the website, you can download a variety of outreach resources we've developed, flyers, small business cards, information sheets that provide information about how to report sexual harassment and how to identify it. The website itself also provides some background about how to identify and issue spot sexual harassment in housing, a little primer on sort of what DOJ can do in these cases, and some summaries of some recent cases. The phone number here is a dedicated phone number that we've set up specifically to receive complaints of sexual harassment in housing, and complaints or referrals can also be emailed to the fairhousing@usdoj.gov email address. So we're continuing to expand our outreach and really want to encourage anyone who wants to learn more about this or to report this conduct to contact us by any of these means.
Yeah, thank you, Katie. We had a question come in that I'm going to refer to Kelly. Someone asked to share the information about the standards of proof in sexual harassment lawsuits.
Standards of proof about whose burden it is to prove what? Is that what what was on our clients, what they had to prove?
Yes, I think I'm sure that's what the questioner meant was, what is the standard of proof and the burden and how you set up a case.
Okay, sure. And I'm sorry, it wasn't a deer that got me, but my internet connection went out, so I apologize.
Might have been a deer.
What'd you say?
Might have been a deer.
It could be worse. So I'm thinking about Kayla. So, but anyway, so I apologize that I was left out. Well, for the burden is primarily on the plaintiff for the entire time of approving the violations, whether it's the discriminatory statement, it's the hostile environment, the act itself. That's all going to be pretty much on the plaintiff. I would say, with the clients, and I don't know if this is where I got cut off, but and of dovetailing a little bit of what Katie was saying, it was huge uncovering and finding more survivors of this, because a lot of things in our clients' background could have been used to attack their credibility. I was sharing about Ms. Sellers and others. There had been some criminal background, some other things going on. One of the clients at the end was saying that she never thought she would have been believed. She never thought that Fort County would be held accountable to this. So finding more survivors is huge, because it goes to bolster your client's story. And if it says, well, it's he said, she said, but then when it's she said, she said, she said, she said, and these are people that don't know each other that are saying the same thing, that's huge. Also, and I don't know if I got cut off, but with Rule 415 under the Federal Rules of Evidence, how victims of harassment can testify against the defendant and to the jury about the defendant's propensity to harass. So having these survivors come forward, and as what Katie had said, if there's one, there's more survivors, even if it's just you get the one case coming in. And so the burden was primarily obviously all on the plaintiffs to be proving the elements of each claim. We knew that obviously going in, and that's why we were trying to find as many, after the case was filed, trying to find as many survivors as we could.
Yeah, and in my experience, sexual harassment is one of the most difficult types of cases to find evidence on, because a lot of times the landlord is smart enough not to have anyone around. I mean, they're not going to have anyone around when someone else, when he's going to proposition someone. It says, okay, so another question is there any chance to bring defamation lawsuit if plaintiff cannot prove the harassment case? Kelly?
Why are you picking me?
That's what happens when you go away and come back.
I go away, it was like, okay, Kelly gets all the questions. All right, so I think that I've seen that play out, not in the case that I was involved in or the seller's case, but I've seen that obviously in the news of some of those, the defamation being played out. I mean, you would have to have, there are obviously the defenses to it, but I think that is something that that needs to be thought about, is something that the defendant could be alleging in response. The more survivors that you have are people that are corroborating, or we had clients that had audio, that they are recording some of this. So obviously that could be used to counter such claims as defamation and so forth.
And I will say that oftentimes in sexual harassment cases, we will go ahead and file with HUD first and let them begin the investigation process. And sometimes that will spur the respondent to go ahead and settle. Unfortunately, in Kayla's case, the landlord first offered her like $200 or something just highly insulting, and so she wouldn't take it. But so if you file and I should say this, if you do file an administrative complaint with HUD or your state fair housing organization, then if it gets to the point where you are ready to file the lawsuit, then you can always administratively withdraw the complaint and then proceed into court. We have done that also, especially if you're bumping up on a statute of limitations deadline. Also with HUD, the statute of limitations tolls. It stops running while they are investigating any type of complaint. So that preserves your time a little bit. And again, sometimes it will go on and spur the landlord into a settlement, a conciliation, which is in the best interest of our clients, because Kayla's case drug on. Like everyone else, HUD is short-staffed, and the landlord was able to drag them off into the weeds with some of his deception. And so it took a while. And this, obviously the sooner that you can settle it for your client, especially in a sexual harassment case. And also if they know that if we can go through the administrative process, they're not going to have to, if it can settle, they're not going to have to get up on a witness stand and testify. If they would do an interview with HUD over the phone. And so sometimes I think our victims, I think that's a little easier on them. Katie, do you have anything to add about the questions about proof? And I know in your cases, the person's not named generally.
Yeah, but in the course of obviously litigating and discovery and talking about potentially mediation and settlement, I think to Kelly's point and your point about finding additional aggrieved persons, additional survivors, victims, really does help. The majority of our cases do settle, and I think that is largely because potentially we have in most cases a large number of accusers and people who are making these allegations. So the defamation question hasn't really come up that I'm aware of in a lot of our cases, I think once people see the evidence against them, this is not the type of case where you necessarily want to have people, going up at trial and telling these stories.
Yeah, we did have a case one time where the client called me very shortly after it happened. She was hysterical, and she had also called her boyfriend, and while she was hysterical, and at the time we didn't think we had any corroborating evidence, so we were going to use the contemporaneous testimony of, she immediately called her boyfriend and was hysterical. And so then it just kind of lucked out, how sometimes you're talking to people and say, oh, I found a new place to rent and blah, blah, blah. And it turns out we did find someone else that this landlord had done that to. And he settled pretty quickly after we found that other person. But it's a very difficult case type of thing to prove. If they've got text messages, try and get that phone and keep it so that it can be preserved in the chain of evidence. We had her text messages transcribed by a court reporter in case something like that happened, or like if it crashed or something. So we immediately had them transcribed. I haven't seen any other questions coming in. I don't know. I guess y'all did just such a great job.
Well, I wanted to add to that question about, the question about the defamation. I will say in another case, the first case we filed in state court, the private landlord did counterclaim malicious prosecution. So, I know it's different from defamation, but that was something that he did, counterclaim with, and that was a factor in, ended up being a factor in the case and how and the resolution of it. So, there's ways.
I would add, in addition to, it's not necessarily just finding, the fact that you find additional people who have been harassed, but at least we found there's often, the harassers tend to have kind of particular MOs. There are certain things that you hear from people that are consistent over a period of time, whether it's someone who lived there 5 years ago or someone who lived there 2 years ago that have never spoken to one another. And there tend to be some kind of unique things about each particular harasser that you can sort of find consistency among the accounts that people provide as well.
Mm-hmm. Yeah, unfortunately, a lot of times our clients, when they move and get out of the situation, then they just don't want to go forward. They want to let it drop. But now that we've had this conversation with DOJ, then we may refer them to DOJ. So here's a question. Let's see. Why doesn't DOJ name individual victims in their complaints? Does DOJ just describe the circumstances of the harassment?
Yeah, so there's different points in the litigation where we might identify who the aggrieved persons are. And so when initially filing the complaint, like I said, it is our general practice to, we'll give the time period of the allegations. There will be some level of specificity about, what exactly was occurring. And then, we keep the identities private. Then we will obviously disclose them to the defendants in the course of the litigation so that people know who are, the people are who are making the claims against them. But, at different points in time, people may decide that they don't want to participate in the litigation. The federal litigation can drag on for periods of time, and we don't force individuals to participate in our cases. So this sort of, until the time that the case settles, that people can choose whether or not they want to be involved, and so we can kind of have different pools of aggrieved persons throughout the litigation.
Mm-hmm. Does anyone else have any questions or comments? We're coming up on the end of our time, but I think we all have our contact information. I think we've all got attachments on there, and our contact information, certainly through Paula at the ABA. If you have questions for one of us, I'm sure she can link us up and get you connected with us. Let's see. Oh, the person who asked about the names real quick says, is this a new practice? I only ask because the Weigel complaint names the aggrieved person. And yeah, and so I was going to say that's different because it started out as a HUD complaint, and then she elected to go into federal court, so it was a specific complaint. Is that right?
The statutory authority that gives us the ability to bring those cases is based on the fact that they filed a HUD complaint. So the fact of Kayla filing a HUD complaint and the specific timing of that is integral to our jurisdiction to file that specific lawsuit. So the complainant has to be named in those cases.
Right. So that's it's kind of two different types of situations. But it is good to know that if they don't want to really participate, but it's something that DOJ should know, then I think, it's very good to know that. And someone asked for your last name, Katie?
Raimondo.
Yes.
On the slides.
Yes, that's what I thought. Okay, Paula, are you there? Do you want to close this out?
I just want to thank you so much for participating in this amazing webinar. I learned a lot, and we're just really appreciative that you all could come on today and talk to us. I will be sending out the recording of the program along with the slides and contact information. So thank you for everyone that watched, and we hope you'll share our recording and our materials. And thanks again to the panelists. This was great.
Thank you.
Thank you.